Hi everyone. I am going to be going through Wayfarer's response to the New York Times as their state lawsuit, where they have filed for a summary judgment. So Wayfarer have responded today, and New York Times reply is due on the 17th of March. So this isn't too long of a filing, actually. It's only 15 pages, and a few pages of that are going to be indexes and stuff. I went through that new complaint from Celeste Smith against Wayfarer Foundation, Wayfarer Pathways, and Steve Saras. And I just did a read through, and I said, I think I kind of ended the video with, leave it with me for a bit. I need to really think about this and digest all of this complaint. I will be doing a follow-up video to kind of go through that a bit and, sort of track some of the allegations that she's made with some of the things that I've found. I'm not happy at all with that complaint. I think it's a absolute crock of shit, to be honest. But there we go. I'm looking forward to the Wayfarer response to that. But I don't love that complaint at all. And I do think it's in my own opinion, I feel like it's an opportunistic, and she's just kind of piling on. I don't think she's been put up to it by the Livelies, but I just feel like everyone's just jumping in now, and oh, they're being sued. Let's go for it. So, but that complaint was just absolute crap. So if you want to listen to that, you can go and check out my video. Went through it all, and I will just do a follow-up video basically on looking and dissecting her allegations and claims, just taking them apart basically. All right, so New York Times and Wayfarer. Let's get through this. Okay. Defendant Wayfarer Studios respectfully submits this memorandum of law, A, in response to the motion by plaintiff, the New York Times Company, for summary judgment, and B, in support of Wayfarer's cross motion to stay this action pending the final resolution of a related matter pending before the United States District Court for the Southern District of New York. So they are looking to put this case on hold until the Lively case has been resolved effectively, which is sensible, I think, because I do think it has bearing. Excuse me, including staying any interim deadline to substantively oppose the time summary judgment motion. Preliminary statement. This action and the SDNY action arise out of a dispute between actress Blake Lively on the one hand and Wayfarer, its co-founder Justin Baldoni, and others on the other hand, in connection with the production of the film It Ends With Us. In the first, as a footnote, Lively was the lead actress in the film. Baldoni was the director of and the lead actor in the film. Okay. In the first filed SDNY action, Wayfarer, Baldoni, and others asserted claims against the Times for defamation and false light in connection with an article and related video published by the Times in December 2024, which purported to detail a non-existent smear campaign allegedly waged by them against Lively in retaliation for her accusations of misconduct on the set of the film. In June 2024, the federal court dismissed the claims against the Times on a motion to dismiss. Thereafter, in October 2025, the federal court issued an order effectively extending Wayfarer's time to appeal the dismissal of the claims against the Times to align the timing with the legally and factually overlapping related action, which remains pending. And I'm glad that Wayfarer have pointed out that, we still have a right of appeal. We've just, we basically, the judges asked them to basically hold off appealing and stop the clock because they are waiting for Judge Lyman to decide on Lively's rule section 47.1 treble damages, etc., and remedies. So Wayfarer can't actually appeal until that decision has been made on that motion from Lively, and that is so that if Lively gets denied, then while Wayfarer are appealing their complaint, Lively can at the simultaneously appeal Judge Lyman's decision if it goes against her. On the rule, on the section 47.1 damages. So that's what that is. And Wayfarer just basically spelled that out for the court. Like, look, we've got to stop the clock on appealing the dismissal of our claims. So there is that, because the way the New York Times framed it in their motion for summary judgment was that they did not intend to appeal. This also gives me a little hint that Wayfarer are probably considering an appeal. A lot can change between now and then, but this is the first sign that I'm taking that they're at least considering it, which is, wonderful news. Okay. Notwithstanding, in September 2025, the Times prematurely commenced this action against Wayfarer, seeking to recover, under New York's anti-SLAPP laws, its attorney's fees and costs incurred in the defense of Wayfarer's claims against the Times in the SDNY action. And there really shouldn't be that much for them to claim. I know they seem to be claiming quite a lot, but really all they really did was file a motion to dismiss. They had a stay of discovery, so they weren't involved in any of the discovery process. And then they were dismissed. There really was not much for them to do. They had to participate in some stuff and be copied into stuff in case they weren't dismissed. But, they weren't actively involved in all the discovery that, Lively, Wayfarer, Wallace, etc. were all involved in, even Sloan. The Times acknowledges that its anti-SLAPP claim is entirely predicated on the federal court's dismissal of Wayfarer's claim in the SDNY action, which Wayfarer intends to appeal. Oh, there we go. They intend to appeal to the United States Court of Appeals for the Second Circuit. So you heard it here first. Wayfarer is fully intending to appeal. Again, a lot can change, and they are entitled to change their mind between now and whenever the date is that they can appeal. But they have, at this point in time, they are conceding that they do intend to appeal. Accordingly, this action is premature and should be stayed to avoid significant duplication of effort, waste of judicial resources, and likelihood of inconsistent rulings. Right, let's go on then. I'm excited by that, though. I'm really excited by that. I'm going to do my happy dance once I've finished this video. All right, so statement of facts, background. A lot of this we will have heard already, but we're just going to go through it anyway. On December 20th, 2024, Lively filed a complaint with the California Civil Rights Department against Wayfarer and 10 other defendants, alleging that she was sexually harassed during the production of the film and subjected to a retaliatory smear campaign, concurrently with the film's premiere in August 2024. Since no later than October 2024, Lively had been collaborating with the Times metadata. Since no later than October 2024, Lively had been collaborating with the New York Times on a one-sided and defamatory hit piece on Baldoni and his colleagues. So we obviously know of Van Zandt. That was in October. The lawsuit was filed on September 27th, but that subpoena was dated October 1st, I think it was. And we know from the metadata that I found, the October 31st metadata, that was in the embedded text messages of the New York Times article that, you know, they had clearly been working on this since then at least. And that is what Wayfarer are referring to. A lot of people know this, but for anyone who isn't aware now, because it's been a year, yes, that the metadata, I found that. And it's always like, it's a sense of pride actually every time Wayfarer kind of refer to the October, you know, the evidence of that there is of the October collaboration. So, you know, it is a sense of pride that they can throw that stuff like that in, and hopefully it will help their case. Okay. On December 21st, 2024, the day after the CRD complaint was filed, the Times published an article authored by Megan Twohey and others with the headline, "We Can Bury Anyone Inside a Hollywood Smear Machine." The article purports to detail an alleged campaign to tarnish Blake Lively after she accused Justin Baldoni of misconduct on the set of It Ends With Us. On the same day, the Times published a video in which Twohey purported to explain the story from the Times' point of view, and they're referring to that video. The SDNY action. On October 31st, 2024, Lively commenced an action in the federal court entitled Lively v. Wayfarer Studios against Wayfarer, Baldoni, Jamie Heath, Steve Zarowitz, It Ends With Us movie, Melissa Nathan, the Agency Group, and Jen Abel. The complaint asserted claims for, among others, sexual harassment and retaliation. On January 16th, 2025, the Wayfarer parties commenced a separate action in the federal court against Lively, her husband Ryan Reynolds, her publicist Leslie Sloan, and Sloan's company Vision PR. On January 30th, 2025, the federal court consolidated the two cases into a single action pursuant to Federal Rule of Civil Procedure 42A2 for purposes of convenience, expediency, and judicial economy, and finding that the two cases involve common questions of law and fact. On January 31st, 2025, the Wayfarer parties filed an amended complaint adding the Times as a defendant and alleging that the Times defamed them by publishing the article and the video. On February 28th, 2025, the Times moved to dismiss the amended complaint pursuant to Federal Rule of Civil Procedure 12b6. The Wayfarer parties opposed the motion. On June 9th, 2025, the federal court issued an opinion and order in which it dismissed, inter alia, the Wayfarer parties' defamation and false light claims against the Times without leave to amend. On September 12th, 2025, the Times moved for entry of final judgment in its favour against the Wayfarer parties pursuant to Federal Rule of Civil Procedure 54B. The Wayfarer parties did not oppose the motion. The federal court's extension of time to appeal from the dismissal order and judgment. So here we go. On October 17th, 2025, the federal court issued a memorandum and order directing the parties to show cause why final judgment should not be entered in the Lively case. Well, it's actually the Wayfarer v. Lively, Reynolds, etc., case, which is, they are consolidated, but they are separate lawsuits. So Lively's lawsuit against Wayfarer is one lawsuit, and Wayfarer's lawsuit against Lively, etc., Reynolds, the New York Times, Sloan, is in and of itself a separate lawsuit too. They were just consolidated because there was a lot of overlap. So, so Lyman directed the parties to show cause why final judgment should not be entered in the case, which is the Wayfarer v. Lively, Reynolds, Sloan, New York Times case, and why the Times motion should not be dismissed as moot, given that the federal court had already granted various defendants' motions to dismiss, including the Times motion to dismiss, and had already Given that the federal court had already granted various defendants motions to dismiss, including the Times motion to dismiss, and the time for the Wayfarer parties to file a further amended pleading had expired. Sorry, I got distracted by my phone going off then. The Wayfarer parties had no objection to the proposed relief and thus did not respond to the memorandum and order. The Times also did not respond to the memorandum and order. By letter dated October 24, 2025, Lively requested that the federal court hold in abeyance the Wayfarer party's time to file an appeal from the dismissal order pending the entry of an order resolving her motions for fees. And then there's a quote here. In a memorandum and order dated October 31st, 2025, the federal court explained, the federal rules of civil procedure permit district courts to treat motions for attorney's fees as Rule 59 motions for purposes of the federal rules of appellate procedure. And the federal rules of appellate procedure explain that where a Rule 59 motion has been filed prior to a notice of appeal, the time to appeal begins when the district court rules on that motion, not when it enters judgment. The federal court further noted that to increase judicial efficiency, a district court is therefore permitted but not required to delay the finality of the judgment for appellate purposes under revised Federal Rules of Appellate Procedure 4A until the fee dispute is decided. The federal court held that such approach was warranted, determined that Lively's pending motions for attorney's fees qualify as motions for attorney's fees under Federal Rules of Civil Procedure 58, and that judicial efficiency would be best served by simultaneously handling any appeals related to the request for fees with any appeals from the underlying judgment, given the significant substantive overlap between the two. Notably, and particularly relevant to Wayfarer's motion to stay this action, the federal court held that any prejudice to the Times caused by delaying the time to appeal is insufficient to overcome considerations of judicial efficiency and the prevention of piecemeal appeals. Simply put, the prejudice the Times has identified, if any, is minimal, while the benefit to judicial efficiency in handling appeals simultaneously would be substantial. Accordingly, the federal court A ordered that final judgment be entered in the Wayfarer case. B, pursuant to Federal Rule of Civil Procedure 58E, granted Lively's motion to treat her pending motions for fees as motions under Federal Rule of Civil Procedure 59 for purposes of Federal Rule of Appellate Procedure 4A4, and C, denied the Times motion seeking entry of partial judgment as moot. On October 31st, 2025, the federal court entered a judgment in the Wayfarer case. The Wayfarer parties intend to appeal the dismissal order and judgment. I love reading this. I feel so happy. The grounds for appeal include, but are not limited to, the federal court's erroneous determination that the Wayfarer parties failed to allege that the Times statement in the article that they engaged in a smear campaign was made with actual malice, and B, presumption on a Rule 12b6 motion that the Wayfarer parties had spread negative content about Lively. Based upon self-serving and cherry-picked evidence provided by Lively to the Times instead of accepting the Wayfarer party's well-pleaded allegations as true. Okay, so now we're getting a hint of what they are, what grounds they're going to appeal on. So, firstly, Lyman's assertion that the Times, their statement that Wayfarer had engaged in a smear campaign, Lyman, kind of made the assumption that it wasn't made with malice. And also he did weigh in and kind of give his opinion that he believed that the Wayfarer had spread negative content about Lively, but he based that largely on the statements that were kind of cherry-picked. So now we've seen so much more, all the unsealed documents, and as I keep saying in every video, that is just the absolute first layer of the biggest iceberg. There will be so much more that they will have in their possession from discovery. All we have seen so far is stuff that has been attached to emotion. You know, there is more. There's a lot more. And the evidence we've already seen speaks volumes about what was really going on. I really want to see the rest of it, because if what Lively has added as her evidence to oppose the motion for summary judgment or the judgment on pleadings, if that's the best she's got, I'm deeply worried about her. Well, I'm deeply worried about her anyway. But, like, there's no evidence. There's nothing. So we've now got a bit of an understanding of Wayfarer's thought process in when it comes to the time that they appeal the dismissal of their complaint, and now we know for sure that they intend to appeal it too. Guys, this is big news. This is big news. Okay, so Wayfarer parties' time to appeal the dismissal order and judgment has not expired because Lively's motion for fees has not been decided by the federal court. And I will say this. Firstly, I was annoyed that the New York Times kind of misrepresented that, they have not, they're out of time to appeal, when the New York Times knows damn well that's not the case. The judgment is attached to this memorandum. There are some exhibits. I'm not going to go through them because they are stuff we have seen already. Like the complaint, like the June 9th dismissal order, and the kind of the motions that were filed in relation to Lyman entering judgment, Lively's request to, hold the appeal window in abeyance whilst her fees motions were, decided, etc. And then the decision on that. So we've seen all of that over time, so I won't go through all of that. We continue. The status of Lively's claims in federal court. Well, if I had to give her claims a status, I would say dead on arrival, but that's just my opinion. Wayfarer parties' motions for judgment on the pleadings and for summary judgment, each of which seeks dismissal of Lively's claims against them, are sub judice. The trial of Lively's claims, if any, remain after these dispositive motions are decided, is scheduled to commence on May 18th, 2026. I love that. I really love that. The trial of Lively's claims, if any, remain after Lyman has gutted them for the summary judgment and judgment on the pleadings. It's been too long since I've seen a really good Kevin Fritz filing, so I'm appreciating this. This action. Okay, so we are coming close to the end now. Meanwhile, on September 30th, 2025, the Times commenced this action against Wayfarer seeking to recover, pursuant to New York's anti-SLAPP laws, its costs, fees, and expenses incurred in the defense of the Wayfarer parties' claims in the SDNY action. Specifically, the Times alleges that the Wayfarer parties' claims against the Times in the SDNY action constituted an action involving public petition and participation, as contemplated by the anti-SLAPP law, and that the dismissal order makes clear that Wayfarer and its affiliates both commenced and continued the lawsuit against the Times without a substantial basis in fact and law, thereby entitling the Times to the recovery of its costs and attorney's fees. On December 2nd, 2025, Wayfarer filed its answer, which denies the substantive allegations and includes various affirmative defenses. On January 14th, 2026, the Times moved for summary judgment on its sole claim for violation of civil rights law sections 70A and 76A. In the motion, the Times argues that the federal court's dismissal of the Wayfarer party's claims against the Times for failure to state a claim under Federal Rules of Civil Procedure 12b-6 proves that the Wayfarer party's lawsuit against the Times was commenced or continued without a substantial basis in fact and law. Okay, legal standard. CPLR 2201 states that, except where otherwise prescribed by law, the court in which an action is pending may grant a stay of proceedings in a proper case upon such terms as may be just. The determination as to whether to grant a stay rests with the court's direct discretion. Although there is some authority that a stay is justified only where there is complete identity of the parties, the causes of action, and the judgment sought, there is substantial authority holding that a stay is a provident exercise of discretion, even absent complete identity of the parties and issues, where there are overlapping issues and common questions of law and fact, and the determination of the prior action may dispose of or limit issues which are involved in the subsequent action. Okay. In general, the duplication of effort, waste of judicial resources, and possibility of inconsistent rulings in the absence of a stay outweigh any prejudice to the party opposing the stay. Courts also consider the sequence in which the actions were commenced and usually defer to the first filed case. Argument. These discretionary factors weigh in favour of granting a stay. The Times and Wayfarer are parties in both the SDNY action and in this action. There is no dispute that there are overlapping issues and common questions of law and or fact. The Times complaint and its summary judgment motion both contend that the Times is entitled to a judgment under New York's anti-SLAPP law because the federal court issued the dismissal order dismissing Wayfarer's claims against the Times. The Times argues that the federal court's dismissal of Wayfarer's claims, pursuant to Federal Rules of Civil Procedure 12b-6, establishes in of itself that Wayfarer's lawsuit against the Times was commenced or continued without a substantial basis in fact and law, in violation of New York's anti-SLAPP law. However, if Wayfarer is successful on its appeal from the dismissal order and its claims against the Times are reinstated in the SDNY action, the Times will no longer have any basis to allege, as it does, that Wayfarer's claims against the Times in the SDNY action lacked a substantial basis in fact and law. Without a stay, there is a risk of inconsistent rulings. This court may determine that Wayfarer's claims were commenced or continued without a substantial basis in fact and law, while, to the contrary, the Second Circuit decides that Wayfarer properly stated claims against the Times in the SDNY action for defamation and or false light, and reverses the dismissal order. Judicial and party resources will be wasted without a stay because this court will have to determine the Times' summary judgment motion, hear oral argument, schedule conferences, potentially oversee discovery, etc., none of which will be necessary if Wayfarer's claims against the Times in the SDNY action are reinstated. Okay, principles of comity also favour a stay. The SDNY action was filed 9 months before this action. Wayfarer and the Times have engaged in substantial motion practice in the SDNY action with respect to Wayfarer's claims against the Times, and the parties will continue to expend significant resources in the SDNY action by virtue of Wayfarer's forthcoming appeal from the dismissal order. Neither the Times nor Wayfarer will be prejudiced by a stay of this action, particularly if Wayfarer is successful in having its claims against the Times reinstated in the SDNY action. There is no claim for the Times to pursue because its claim is predicated on the dismissal order. Moreover, the Times cannot complain that Wayfarer's time to appeal from the dismissal order has been unjustifiably extended by the federal court, because the Times failed to respond to the federal court's order to show cause. On the other hand, if a stay is not imposed and if the Times is granted summary judgment herein, Wayfarer will be prejudiced by having to satisfy that judgment and potentially appealing such judgment to the appellate division, while pursuing its appeal to the Second Circuit from the very order in another case, the dismissal order, that served as the basis for that judgment. That's really fair arguments. I have to see what New York Times say, but I mean, that's completely reasonable. It is, they're just saying, just pause everything. Let's stop spending money on this, because actually this case may not be, needed if we successfully appeal, the dismissal of our complaint against the Times. And that's absolutely fair and reasonable. And the New York Times is it's not like they need the money. They're not an individual who's, sold their home and everything to pay for the legal fees and desperately needs their money back. So, conclusion. For the reasons set forth in this opposition and the accompanying papers, the court should stay this action pending the final resolution of the SDNY action, including a stay of any interim deadline to substantively oppose the Times summary judgment motion. And there we go. So we'll see what New York Times come back with. I'm curious. But there we go. Breaking news, guys. Wayfarer intend to appeal, and now we know the grounds for the appeal against the New York Times. To be very clear, they may have different grounds for the other defendants. They are specifying here that these are the grounds they intend to pursue against the New York Times. All right, guys. Please don't forget to like and subscribe. Really, really helps me out. Thank you for listening, and I will see you soon.